Well, hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. And I couldn't be more thrilled. I know I say this all the time, but truly, I am joined today by our senior attorney and my dear, dear mentee, Lindsay Schoonmaker. Lindsay, welcome.
Carolyn, thank you for having me today. It's always
Of
good to
course.
join one of your webinars.
Yes, thank you for joining. And today we're going to be talking about subparagraph M and good faith investors. So this is a bit of a series that we're doing. This is our third webcast featuring subparagraph M and good faith investor protections. And I thought last time it was sort of more of a focus from the project or the regional center's perspective. And so this time I thought we would cover these questions related to subparagraph M and good faith investors from the investor perspective. And for that, I brought in attorney extraordinaire Lindsay Schoonmaker. And so what we thought we would do today is have this be more of an interactive FAQ and answer session. We have been fielding a lot of questions from investors, from our own clients, and through our various communications channels on by email, contacts at our WhatsApp, EB-5 community, and so on. So our communications team has collected those questions, and we've curated a number really focused on pre-RIA EB-5 investors, and we're going to tackle those in the next half an hour or so.
Yeah. So to kick us off, I'm gonna, pose some questions, and Carolyn and I will have a discussion on them. Carolyn, what does it mean to be a good faith investor, and what is going to trigger those protections that are so important from subparagraph M?
Yes, absolutely. This is a really important question with some important distinctions, because the related question we get a lot is, I know our project's not doing well, or I feel like it may not be doing well, and I may not have all the information because I'm maybe not, I'm having trouble communicating with my project. And so would I qualify as a good faith investor? And we have clear triggers for good faith investor protections, thus defining what a good faith investor is. And that is regional center termination or new commercial enterprise debarment or JCE debarment. So it's regional center termination or debarment of your NCE or JCE. Okay, so that's the precondition. Now, the follow-up question that Lindsay just asked is, okay, so what triggers my good faith investor protections? Let's say my regional center has been terminated, I know it. Am I now the beneficiary of subparagraph M protections? And the answer is there is a clear trigger, and the trigger has to be in place first. And that is the issuance of the 180-day notice from USCIS that notifies you, the investor, that your regional center has been terminated or your new commercial enterprise or JCE debarred. Can I say a couple more points on this, Lindsay?
Absolutely.
So in September, back in September 2025, USCIS began issuing these 180-day notices en masse. So there are a large number of these 180-day notices that were duly issued to the affected investors of these terminated regional centers. To date, our practice is not aware of any NCE debarments or 180-day notices associated with any debarment.
And we also heard from people who were anxious. I've heard some other investors have gotten the 180-day notice. I haven't gotten mine. What should I do? What should people do in that situation?
Yeah, I think the first thing to do is to get your facts. Yes, because there's a lot of hearsay in our space. I hear that somebody got an 829 approval, or I hear that somebody else got an 829 denial, on project related reasons. And, these are important facts to really have a firm handle on. So I would say if you have heard as an investor that your regional center has been terminated, the first thing to do is to check the USCIS website, which is publicly available, and it lists all of the regional centers that have been terminated. So that's the first thing. Now, there is a gap between regional center terminations, typically, and the 180-day notices being issued. So if you are hearing that 180-day notices have issued, get a copy, because that 180-day notice is going to be very clear about what's happened as the triggering event and whom, regional center's name, and that it's been terminated.
Great. So let's talk about that a little bit now. What happens for an investor when they get this 180-day notice? What are their options? Particularly for those pre-RIA I-526 investors.
Totally. So the first thing is to calendar the response date.
We do a lot of calendaring.
We do a lot of calendaring. Calendaring is important. Monitoring your deadlines in immigration is critical. And so for all of the September investors who received the 180-day notices, your 180 days is going to be the end of March. And so put that in your calendar. You must respond by that date. Now, these 180-day notices give investors 3 options, and they're numbered options 1, 2, and 3. And so should I pause here, Lindsay, or should I go into those? Should we talk about those options?
Yeah, let's talk about those 3 options and what it looks like for the investors.
Okay. So option 1 is basically, I'm fine, is the response there. It says, I continue to meet the eligibility requirements and I'm good. And we'll come back to each of these options and talk a little bit about them. They're important. Option 2 is the new commercial enterprise. My new commercial enterprise is reaffiliating with a regional center in good standing. And so that's option 2. Now, typically, because it's an NCE action, this is not an option that the investors typically have direct control over. And again, we'll come back. There are some instances where an investor and the NCE manager could be in conversation about exercising this option. But it is an option that depends on NCE action, option 2. Option 3 is reinvestment in a qualifying investment. And the important question here is, well, I'm a pre-RIA investor. Does the qualifying investment mean investment at the 800,000 level or the 500,000 level? And importantly, USCIS has issued clarification on this. Pre-RIA investors, it's the 500K level.
So I'm an investor, I get my 3 options and I'm looking through and deciding what to do. Let's go back to option 1 and think about what it means for me if I either already have I-829 approval or I have my 829 pending, and we know the jobs have been created, I met my sustainment period. What does option one look like for me?
Yes, yes. To me, option one is for investors who are 1000% certain that they need no subparagraph M protection. And so let's take your example of I-29 approved investors. I think the presumption is that, yes, I'm good, but know that for legally erroneous approvals, they're subject to revocation. So I think even in a case that appears so cut and dry, like, oh, I have an 829 approval, I think it's very important to have absolute certitude on the non-revocability on that approved 829.
Ask the questions.
Ask the questions. Yes, yes. Similarly then, with a pending 829, you've got a little more risk, don't you? Because it's still out there. And so to your point, Lindsay, ask the questions. Is there any possibility whatsoever that there could be a challenge to this profusion of jobs that I have submitted my 829 with? Is there anything, anything under there that I should be concerned about?
Yeah.
And I think, there are instances where within, what is the term, like metaphysical certitude, we can't be sure of absolutely everything at any time, but to the extent that, we can be nearly there, like super close. Yeah.
Yeah, I mean, we were talking earlier about a regional center that just chose not to find investors post RIA, but they've met all of their requirements pre-RIA. They've served their investors and have provided everything that is needed, and the jobs were created. Then there's
Yes, like our
there would
clients.
be exactly, there would be a reason why option one could really work for people. And you would not have to worry just because you get that 180-day notice and your regional center has been terminated, that you would absolutely have to reassociate.
Right. And keeping in mind that in that, super good actor scenario, they are still your NCE manager. And so they still maintain and embrace, right, their fiduciary obligations to you.
All right, so let's talk a little bit about option two, which can be frustrating for investors because they have such little control over it.
Yes,
And I feel like
indeed.
that's the question that we get most often is, well, I want to stick with the NCE.
Yeah, exactly. Because it's the thing you know.
Exactly. You did all your research. You
That back
chose the
then, and there's a
exactly.
relationship, and
Mhm.
now should I leap off to something I don't know and maybe incur the same risks again?
Right. Option two is very appealing.
Yeah, it is. Like it's an emotionally appealing option. Um, so, and yet it's tricky because it is the NCE has to reaffiliate. And so there are these business factors that have to line up. Like there has to be an open regional center in good standing that somebody has to have done their diligence on, and they have to agree, and the commercial things have to be worked out. Um, I think it might be helpful to talk about scenario where it could work, right?
Mhm.
And these are scenarios we're advising,
Absolutely.
is where you have an NCE manager. There's so the premise has to be there is that triggering event. There has to be that 180-day notice. Let's say that's happened. And the NCE manager wants to do everything in its power to keep their investors safe, their immigration journeys protected to their fullest extent. And so and they're in communication with their investors as well. So in those instances, and they know for one reason or another, there are regional centers that they can readily reaffiliate with. Well, in that instance, that possibility opens up the NCE option 2, the NCE reaffiliation option. Now, I think it's got to be said that with all of these options, there is the question of, well, I may have more than one option available, which is the best option for me? And which is the best option for the group of affected investors? Now that is going to be entirely case by case and context driven. So we're not going to get into that here. But know that the NCE affiliation option can be available depending on the posture of the NCE manager and the relationship between the NCE manager and the investors. But most of the time, it's not. It is
not an
off the table
option
for various reasons. Yeah.
And so then we get to option 3, which really can help a lot of people preserve their priority date and, make sure children don't age out. And it's a really solid option, although it can be frustrating for people to think that they have to reinvest, particularly if they have to add additional money.
Yes, exactly.
Exactly. So what can we talk through what that would look like for an investor?
Yes, absolutely. The first thing that was interesting to me in advising clients through this, Lindsay, was the variance in investor approaches to this. Some clients have been, where do I sign and where do I go? Is it 800 or is it 5? Right? I mean, it's like, okay. And then we have many clients who are this is distressing, what's the Hobson's choice of, what do I do here? And so the good news is it is 500, not 8 for pre-RIA. Also good news is that recovery of funds is often a part of this. The regional center has been terminated because there were suits of, alleging misconduct and findings and conclusions and SEC involvement and so forth, and successful recovery of funds. And so the investor has available a certain portion in varying amounts that can contribute to a reinvestment of option 3, making a new qualifying investment. So that's that. And then in those instances, they may be given options, as we have seen, that the recovered funds can be sent directly to the NCE of your choice that you direct, or it can be redistributed back to you. Okay, so with option 3, that one would choose probably to execute option 3, the NCE reinvestment of the recovered amounts. Now, if the recovered amounts do not come up to the 500K under current guidance, you do have to top up and do all the same, the sourcing of the lawful source of funds, consistent with, I think most conservatively, post-RIA requirements, and get that package evidencing the lawful source of funds, plus the reinvestment, the subscription, all of that you're signing on to an irrevocable investment with your second NCE.
A minor detail, but people have been hearing about the new form I-527 that has been proposed, but it hasn't been released yet.
Right. Correct. Yes. That's a great question, because option 3 can be exercised by email or by a mailing. And we know these filings are extensive. They should be. So an email filing where IPO email box usually has file size limits may not be the option, in which case the mail option is available as well. Now then, the procedure. We know that the Form 527 has been floated under an APR notice, an APA notice, Administrative Procedures Act. However, that form is not, it's not active yet. As I mentioned in earlier webcasts, I think and I hope that the form will come online and be available before the end of March, before the due date. I am just thinking that, I mean, there's just logic to that.
Mhm.
So I think that could happen, not counting on it, of course. But if we don't have the form and we've got to file to ensure that it's there before the deadline, we'll have to figure out a way to do this.
Yeah. We're actually getting a question from the chat, and two people have very similar questions about, do you have to lock yourself into one option? Can you keep 1 and 3 alive at the same time? Can you hope that your project is going to turn itself around, but still leave yourself the option to make a new investment?
Oh, yes, I know. Maybe USCIS has been, to this point, I think, very acting in concert with legislative intent in its guidance thus far. This is just my gut. I mean, because of course I hope that there'll be all kinds of flexibility in this, but I rather doubt that that will be an option. But if it is an option, I think this is how it would be. So these filings, options 2 and 3, are amendments. They are amendments to the underlying petition. And so we can conceive of these amendments being filed and then perhaps an interfiling or an amendment to the amendment. I mean, so procedurally, it's not like it's impossible. Although I do think there is what's the best interpretation of the language. But I think that my gut tells me that you've got to choose one or the other, and that's it, you're locked in.
This was asked while we were talking about the 180-day notices. So we touched on it briefly, but if an investor did not receive the notice, but they know that they've done their checks that their regional center was actually terminated on, they can see that online at USCIS, and some investors received them and some did not. Is contacting IPO the best course of action? We
have done so and have not heard back, but I think that that would be the appropriate response on IPO's part to issue that notice, because it's in the statute. You know, regional centers terminated, NC or JC is debarred. These notices will issue to the investors. Now, I suppose, our records are imperfect. We don't have records of everybody. I suppose that could be kind of but all the investors that are associated should get these 180-day notices. And I would think notifying the service, hey, you missed one. This investor should be, and having, including all due evidence of that should do it. That should do it. I mean, I'm not saying it will do it, but I'm saying it should do it.
Now we have go ahead.
I was just going to say, and the silver, there is a timing kind of, but if it issues late, then one should also get the 180 days from the date of issue, not from whenever everybody else got it back. It's also worth noting that there is a timing, because under a recent decision that came down in the federal court litigation context. What if my case was denied at time 1 and the regional center is terminated, or maybe the regional center is terminated before my denial, but I don't get the notice and my time runs out for me to do my next thing, whether it's filing a motion to reopen or an appeal. And so far, it's, we had nothing on this question. And then we have this decision that just came down hot off the presses, and it's suggesting that at least one court may think, well, sorry, because it's not a valid, it's done.
Right.
Yeah, so I think there is a timing sensitivity there where, like we said, the trigger for the protections is the 180-day notice issuing. It's not just the termination. So anything one can do to get that, get that notice issued sooner rather than later is good.
Wonderful.
Yeah.
We have another question posed that really is more for the project side, but I think it's important for investors to think about if they are choosing option 3 and looking for a new project. So I'll pose it to you, but maybe we'll put it off till next time.
Okay.
So if an I-956F was submitted or even approved describing a post-RIA project, so only for investments of $800,000 or more, does the project need to amend its I-956F to allow for the lower investment?
Yeah, right. So, right. We've thought about this.
And then all following offering documents need to be amended.
Yeah, I mean, so we have thought about this issue, read through our clients' docs, project clients asking the questions. And I will say, we'll leave the door open to the possibility that the original F filing as drafted could have contemplated somewhere, we could reasonably read into the language in the record that yes, we can sell a unit at the pre-RIA level and absorb subparagraph M, good faith investors. I'm open to that because it could. This is, I think it is the case that in most instances that an amendment would be advisable. And we are working on a number of those F amendments for already approved Fs and pending Fs and interfilings to accommodate.
And so investors who are looking at those documents should be making sure that there is a option for them to buy in at a lower investment level.
Yes, exactly. Well put.
Well, we only have a few minutes left. I don't know if there's any wrap up that you want to discuss, things that we didn't get to that I didn't ask you.
I think we kind of hit it, like these big important conceptual points and some practical pointers. And so I'm feeling good. We got it in half an hour.
Always impressive when that can be done.
Yes. And thanks to everyone for joining and for your excellent questions. I think there's more to say on this. Like I said, this was like our third presentation on subparagraph M and good faith investors. I think there's more to come. So tune in and have a wonderful rest of your day.
Thank you so much.
Thank you, Lindsay. See you next time, folks. Bye-bye. Be well.